Thank you for talking to me. So it was a big milestone when the Constitutional Court said COIDA, this act that we're talking about, that provides for people to be compensated for occupational injuries and diseases that they contract at work and injuries at work. It was a big milestone when it was declared that it's invalid, constitutionally invalid, to the extent that it doesn't include domestic workers in the category of worker or employee. But you are worried 6 months after that ruling came. What concerns you?
So, as you mentioned, it has been 6 months since the Constitutional Court judgment on domestic workers' inclusion in COIDA, which was a tremendous victory for domestic workers in South Africa. One of the concerns that we have now that we are the judgment has been it's 6 months since the judgment has been handed down, is that we're not seeing a lot of movement in terms of, firstly, registrations from employers registering their domestic workers to be covered under COIDA, as well as information about those domestic workers who have retrospective claims, what steps they need to go through to be able to submit those claims. Just now, about 10 minutes ago, the Parliamentary Committee on Employment and Labour, which had a process of submissions earlier this year about this very issue of the inclusion of domestic workers in COIDA, has mentioned that they will be considering additional provisions to make sure that these retrospective claims are accounted for in just looking at the situation of domestic workers as a whole, that they will be considered, their situation will be considered in COIDA. However, I think one of the major things is that we're not seeing that much movement in terms of a call for registrations with employers.
Yeah, so just in simple English, what exactly do you mean by saying you're not seeing movement in terms of employers registering, for the purposes of their domestic employees being able to claim and benefit in terms of COIDA? Simply put, people are not registering their domestic employees in terms of the law. Why do you believe that is?
So very similar to the Unemployment Insurance Fund, the compensation fund is there for employees to receive benefits should they get an occupational injury or a disease. And the responsibility for registration and to contribute into the fund monthly lies with the employer. In March, the Compensation Commissioner made an announcement. He issued a notice encouraging registrations by employers. However, there hasn't been much conversation about that. As far as we know, what we're hearing from the unions is that lots of people are coming forward looking for information about how they can claim, but a lot of their employers have not yet registered for the compensation fund. And so what we are calling to see is an educational campaign for employers, for the public at large, to know that they have the responsibility. If you have a domestic worker under your employment, you have the responsibility to register.
Yeah.
So we welcome.
Yeah.
Sorry, go ahead.
I was going to say, because I wonder how many people know that actually the clock is ticking, that they should be registering to ensure that the people that they employ in their homes actually are able to benefit and can claim for occupational injuries in terms of COIDA. And I suppose other people will wonder what kind of injuries are we talking about here in the domestic work environment. And I suppose in response to that, you will cite for me the example of the case that led to this particular judgment at the Constitutional Court, to say actually your home might seem safe for someone to work in, and you have that contractual relationship of employer-employee, and some people call them helpers, but actually this is an employer-employee relationship that raises rights and responsibilities on both parties. You might think it's safe, but actually dangers lurk everywhere that could lead to injuries. To tell me about those and citing that particular case that led to this particular judgment.
Yeah, so exactly what you're saying, there is this misconception that because the domestic workers' workplace is the home environment, that there aren't any opportunities for them for them to get injured. The case that started the Mahlangu case was about Maria Mahlangu, who was our first applicant's mother, Sylvia. Maria worked in a home in Pretoria, and she unfortunately fell into a pool when she slipped from a step ladder that she was using to clean windows in the outside of the house. And because she couldn't swim, she drowned. And so that's the case that prompted, this movement for the inclusion of domestic workers in Kwaida. We heard about, I think it was all over the news in print media anyway, last week, that there was another domestic worker who unfortunately drowned at her employer's home in Durban. And so drownings, things like dog bites, these are occupational injuries. These are risks that domestic workers could experience, falling from stairs, picking up something that's extremely heavy and injuring their back. These injuries do occur, and therefore it's very important for this category of workers to also be included so that they are able to be compensated should they need to take time off to heal from their injury.
Yeah. Lastly, Kilebogile, the other aspect, of course, of this judgment was that it was unique in a way, with the retrospective application and the ability and the window being opened for people and their descendants to be able to claim for occupational injuries or diseases that happened since 27 April 1994. That's big, but you're seeing obstacles in that regard as well. What needs to happen? Also considering that the clock is ticking, and that the Compensation Commissioner has said, actually, lodge these historical claims now, or else you will lose the right to claim in November.
So in addition to the encouraging of employers to register their employees, another thing that the notice that I spoke about in March, that from the Compensation Commissioner, it had mentioned that retrospective claims would need to be submitted by 20th of November of this year. So essentially, that gives us another 6 months for all of these potential claims that are as far back as 27 April 1994 to be submitted. And as I mentioned at the beginning of this interview, is that just 15, 20 minutes ago, the Parliamentary Committee has actually met, and they were responding to some of the concerns that organizations like SERI had brought up in our submissions to the COID Amendment Bill earlier this year. And from my understanding, what was discussed just 20 minutes ago was that the Department of Labour is going to consider the situation of domestic workers. There's an acknowledgement of the situation of the domestic workers, and especially retrospective claims, that they can't be necessarily treated as other claims. And so therefore we're hoping that soon we'll get clarification from the Department of Labour about this deadline of November 2021 for retrospective claims. So our hope is that what the Parliamentary Committee has mentioned in their response to the submissions means that this has changed and that the deadline will be extended.
That's good news, Kilebogile. Thank you so much for that. That's Kilebogile Kono, who is a researcher at the Socio-Economic Rights Institute. Hey, people, this is really important. Hey, get out there, find out the information, register your domestic employee.